Hi, hello everyone. Welcome back to my channel. We are back with the glossary of legal terms. The first phrase today is scintilla of evidence. A scintilla of evidence refers to a very small amount of evidence, barely sufficient to support a legal claim or defense. Courts often require more than a scintilla to proceed with a case. It serves as a threshold test for summary judgment or jury consideration. The phrase highlights the balance between frivolous claims and a substantive disputes. Its scope lies in evidence law and a civil procedure. The next phrase is corpus delicti. Corpus delicti literally means body of the crime, and it refers to the principle that a crime must be proven to have occurred before a person can be convicted of committing it. It ensures that no one is punished solely based on a confession without supporting evidence. This principle protects individuals from wrongful convictions in cases where no actual crime was committed. It is especially important in cases such as homicide, where proof of death must exist. The term emphasizes evidence of the occurrence of a crime rather than merely identifying a suspect. The next term is arrest. An arrest is the act of taking a person into custody, usually by law enforcement, based on suspicion of committing a crime. It can occur with or without a warrant, depending on circumstances and jurisdiction. The person arrested is deprived of liberty and informed of their rights, including the right to remain silent and the right to legal counsel. An arrest must follow legal safeguards to prevent unlawful detention. If conducted illegally, it can be challenged in court. The next phrase is null and void. The term null and void means having no legal force, effect, or binding power. It is used to describe contracts, laws, or actions that are invalid from the outset. Such a declaration may arise due to illegality, fraud, lack of consent, or violation of public policy. Unlike a voidable act, a null and void act cannot be rectified or made valid. It ensures that legally defective arrangements are not enforced. The next phrase is mixed ownership. Mixed ownership refers to a property or enterprise owned jointly by different entities, often involving both a public and private stakeholders. It balances state control with a private efficiency, frequently seen in utilities, infrastructures, and cooperative governance models. The concept safeguards public interest while encouraging capital infusion and innovation. In law, it can complicate decision-making since responsibilities and liabilities must be clearly defined. Its scope extends across housing, corporate law, and public-private partnerships. The next phrase is bar association. A bar association is a professional organization that regulates, supports, and represents members of the legal profession. Its functions may include licensing, discipline, continuing legal education, and advocacy on legal reforms. Some bar associations are mandatory for lawyers to practice, while others are voluntary. They act as guardians of professional integrity and public trust in law. Their role extends to improving access to justice and maintaining independence of the judiciary. The next term is relapse. Relapse generally refers to return to a prior state, often associated with illness, addiction, or criminal behavior. In a legal context, it can relate to recidivism, where an offender re-engages in unlawful acts after punishment. Relapse is significant in sentencing, rehabilitation, and parole decisions. Courts may consider it as an aggravating factor in repeat offences. It highlights the challenges of deterrence and reformation in law. The next phrase is jus soli. Jus soli is a principle of nationality law that grants citizenship to anyone born within the territory of a state, regardless of the parent's nationality. It is often referred to as right of the soil, and a contrast with a jus sanguinis, which bases citizenship on parental lineage. Jus soli is widely applied in countries with a strong emphasis on territorial birthright. It has significant implications for immigration, migration, and demographic policies. The principle helps reduce statelessness, but may raise concerns over birth tourism or misuse. The next phrase is quasi-judicial decision. A quasi-judicial decision is an order or ruling made by a body vested with judicial-like powers but not part of the regular judiciary. Such decisions typically affect individual rights, licenses, or obligations. They require impartiality, fact-finding, and adherence to due process. Administrative tribunals, regulatory authorities, and commissions often issue these. They serve as essential tools in specialized governance. The next phrase is maritime salvage. Maritime salvage is the compensation awarded to persons who voluntarily save a ship or cargo from peril at the sea. It encourages mariners to help others without fear of financial loss. The law of salvage balances rewards with a fairness, considering effort, risk, and success. Salvage is distinct from mere towing or rescue. It requires actual danger. International conventions provide uniform rules for salvage rights. The next term is barrister. A barrister is a type of lawyer who specializes in courtroom advocacy and legal opinions, particularly in common law jurisdictions. Unlike solicitors, barristers traditionally do not deal directly with the clients but are instructed through solicitors. They are recognized for their expertise in presenting cases before judges and juries. Barristers often wear distinctive robes and wigs in court. Their training emphasizes oratory skills, legal reasoning, and interpretation of complex legal issues. The next phrase is scope of authority. Scope of authority refers to the extent of power granted to an agent or official to act on behalf of another. Acts within this scope are legally binding on the principal. Exceeding this scope can result in liability or non-enforceability. It is vital in contracts, employment, and administrative law. Its scope ensures clarity and accountability in delegated powers. The next phrase is just cause. Just cause refers to a legally sufficient reason for taking a particular action, often used in employment and a contract law. In a labor law, it protects employees from arbitrary dismissal requiring employers to show fair and factual reasons for termination. It ensures decisions are based on evidence, not personal bias or whim. The concept supports fairness and accountability in legal relationships. It is a safeguard against unjust or discriminatory practices. The next phrase is Pacta sunt servanda. Pacta sunt servanda is a Latin maxim meaning agreements must be kept. It is a fundamental principle of contract and international law establishing that valid agreements are binding. This principle underpins trust in legal systems and international treaties. It recognizes good faith as essential for legal and political stability. Exceptions exist, but the maxim is a cornerstone of enforceable obligations. The next phrase is Curta Clause, Regional Tenancy Law term. The Curta Clause is a provision found in certain regional tenancy laws in India dealing with the rights of tenants against arbitrary eviction by landlords. It generally protects cultivators who work on leased land by granting them security of tenures. The clause often restricts landlords from reclaiming land without a just cause or due legal process. It has historical roots in customary agrarian practices that favored tenants' stability in agriculture. Its scope lies in safeguarding weaker agrarian classes from exploitation and ensuring continuity of agricultural production. The next phrase is maritime security. Maritime security refers to measures that protect ships, ports and sea lanes from threats like piracy, terrorism and smuggling. It is vital for international trade and national defense. States cooperate through treaties and naval patrols to ensure safe navigation. Security measures include ship inspections, surveillance, and crew vetting. It is a growing field due to global trade dependence. The next phrase is mixed question of law and fact. A mixed question of law and fact arises when both factual determination and a legal interpretation are involved in deciding a case. Courts must first ascertain the facts and then apply the relevant legal principles to those facts. It often appears in negligence, contracts, and constitutional cases. These concepts guide appeals. High courts may intervene if the law was misapplied to establish facts. Its scope lies in bridging pure factual disputes with pure legal questions. The next phrase is corpus juris. Corpus juris means body of law, and it refers to the entire collection of laws in a legal system or jurisdiction. It may be used to describe a specific compilation of statutes, regulations, or legal writings. This term highlights the comprehensive nature of legal principles governing a society. It can apply both to national legal systems and to international or religious legal frameworks. It represents law as an organized and interconnected whole. The next term is justiciability. Justiciability determines whether a matter is suitable for judicial resolution by a court. A case must involve a real present dispute rather than a hypothetical or academic question. It prevents courts from issuing advisory opinions or intervening in political questions. Justiciability requires standing, ripeness, and absence of mootness. It ensures the judiciary operates within its constitutional boundaries. The next term is nullity. Nullity refers to the state of being legally invalid or non-existent. It may apply to contracts, marriages, judgments, or corporate actions found contrary to law. In a procedural law, a nullity can be declared by a court when essential requirements are not met. The declaration treats the act as though it never occurred. Nullity serves as a safeguard to prevent the enforcement of unlawful or defective acts.